Hello, everyone, and welcome to Uncivil Law. I hope you are having a great day. And we are here with our continuing and apparently never-ending coverage of the Vic Mignogna story. We are here today with Funimation's appellee brief. We covered Vic Mignogna's case, we covered his brief, and we are now going to cover Funimation's reply brief. Jamie Marchi, Monica Rial, and Ronald Toy have also filed appellate briefs, or appellee briefs, because they're the appellees. And we're just going to cover Funimation's response today. It is 71 pages long. We're obviously not going to read the whole thing. We're going to skip around and see what it has to say. But when we last left the action, we had read Vic Mignogna's appeal brief, and we found it, or at least I found it, somewhat wanting. I found it to, thin in places. I felt that it just didn't really raise the right issues. I felt that it didn't raise the right questions, didn't really preserve the right issues. It was just not really great in my humble opinion. And this makes the Vic supporters very, very sad. I don't know why they're sad at me. They should probably be sad at Mr. Beard, the person who filed this. But, whatever. So we are here to cover this and see what Funimation has to say. When we last left it, I was estimating that Vic had about a 1/3 chance of winning his appeal. So we're going to see if Funimation, how they respond, if it changes my mind or otherwise alters the odds. So let us get started. And, in the spirit of Nick Rikita, who drinks heavily on stream, of which I approve, today I will be enjoying bourbon and ginger. I've got 1/3 of a cup of bourbon in this glass. I measured it and everything. Very good. Let's get started with this. So we got some table of contents, table of authorities, lots of cases we're going to be citing. Well formatted, nothing not to like, right? We want oral argument, that's fine. Issues presented. Did the trial court properly dismiss the defamation claim when Vic failed to provide evidence of defamatory statement published with actual malice that caused damages? Did the trial court properly dismiss the tortious interference claim when Vic failed to provide evidence of existing or prospective contracts that they interfered with? Probably. Yes, 1/3 before adding ice. I measured 1/3. So it's 1/3 of bourbon in the glass, plus ice, plus ginger ale. 1/3 of cup of bourbon. Yes, before adding ice. An actual 1/3 of an actual cup. I measured it. Did the trial court properly dismiss Vic's theory that Funimation should be vicariously liable for comments that the independent contractor voice published on their social media accounts? Given to other rulings, did the trial court properly dismiss Vic's conspiracy claim against Funimation? Did the trial court abuse its discretion by refusing to consider Vic's late filed Second Amendment petition multiple attachments? That's really, I think the key issue at this point is, for me, that's the key issue. Because, if the trial court abused its discretion by not admitting that, then, all these other issues go the other way. Or at least I think the argument is much, 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 much better for Vic. So for me, number 5 is the operative legal point. An operative legal point that I don't think was particularly well raised on Vic's argument, in my humble opinion. But that's the operative legal point. The trial court abused its discretion by overruling objections to affidavits and other evidence. I don't think it particularly matters that much at this point because, it's a, yeah. Did the trial court properly award Funimation its attorney's fees? Okay. Statement of facts. Okay, and there's a footnote. Judge Chupp refused to consider much of the evidence that Vic now relies on in his brief. Fair enough. So they're not arguably facts because it goes to the issue. But, it depends what is and is not the operative petition and whether or not the second amended is the operative petition or not. Okay, specifically, Vic withdrew his own affidavit plus the affidavits after police questioned the truth of notary certificates. That did definitely happen. So that is withdrawn, right? Without explaining the circumstances, Vic cites his TCPA response, which relies on this affidavit through his brief. In addition, Judge Chupp excluded Vic's Second Amendment petition as untimely filed per the response agreement. The effect of these reasons same below. Well, I really like it. Is this CR a citation to the actual record? CR? 6CR? Or is this, what is this citation? I don't recognize the citation format. 6CR 3224. Well, 3224 suggests that it's a citation to one of the court filings, like the court record or something. I don't know what 6 means, but if like there's an actual statement in the actual record that says that Judge Chip excluded it, that'd be really nice for me to have it. Yeah, so I'd like to get a copy of this. So maybe they included a quote of it somewhere, but I'd really like to see like what the judge actually said. That would be nice. Rather than just citing, why don't you just tell me what they said? Or both. That'd be great. All right, let's go with the statement of facts according to Funimation. Vic Mignogna is a well-known voice actor in the anime world. As alleged in his first amended petition, Vic has performed voices for anime characters for 22 years, mainly in anime. In addition to his voice work, Vic attends 35 to 40 fan conventions per year, which, right away I'm like, limited purpose public figure. When you're doing this for year and year on year, it's like, at some point you're limited public. It's like, yeah, I'm kind of there. Or he earns appearance fees from conventions as well as fees from signing autographs, taking photographs, and appearing on guest panels. Appellee Funimation dubs Japanese anime productions into English for distribution within the United States. From 2004 to 2018, Vic provided voice acting services to Funimation for multiple dubbed anime productions, many of which are part of popular Dragon Ball series. Funimation cast Vic as the voice for Broly, the lead character in the Funimation in the fantasy anime martial arts series film Dragon Ball Super Broly. Funimation released Dragon Ball Broly in 2019. On the same day that Funimation released Broly, Funimation was tagged on Twitter by user @Helena with the question, "Hey Funimation, why do you employ a known pedophile?" That's always a great question. And linked to alleged sexual misconduct by Vic at anime conventions. Yeah, this must be it must be court record. I still don't know what the 6 prefix means. But that's, yeah, maybe it's the sixth volume of the court record. I guess that could be. I'm just not used to seeing that format. With the next few days, Funimation learned of additional allegations of sexual misconduct by Vic at anime conventions through negative Twitter posts about Vic and through other sources within the anime community. Vic responded to negative publicity with a Twitter apology to his many fans on January the 20th. Okay, so the first tweet was January the 16th, and he responds on January the 20th. Same year? Same year. Great. This is heartbreaking. Over the last few days, that'd be the last 4 days apparently, a number of comments and allegations have been voiced on social media. I'd like to share my thoughts. Homophobic? No. Some of my dearest friends are a member of the LGBTQ community, including several I brought into my production family on Star Trek Continues. This is blatantly false. I said many years ago that I do not think a particular character I voiced was gay, contrary to what some fans believe, not because it matters to me at all, but because I was told this was the case. Fair enough. I also like to not to autograph Yowie, because I'm not because I am homophobic, because I do not wish to sign material that was not canon. Okay. Anti-Semitic? I could not even grasp where this was coming from until someone pointed to me moment years ago when I was in panel and referred to a bunch of noise coming from another room jokingly as a Holocaust, which, that sounds, like a dark joke, but the kind of joke that I would appreciate. And if you can't make fun of, Hitler, a la the producers, or a la Melo Brooks, or a la whatever, it's like, if you can't make fun of tragedy, I don't know, you should be able to make fun of tragedy. So anyways, as I said then, it was a metaphor for Armageddon, death, and mass destruction, but not the Holocaust. Could I have chosen different words? Sure, in retrospect. And of course, I'm sorry I offended anyone. I don't think that's anti-Semitic. To say that noise reminds you of the Holocaust, I'm not sure is anti-Semitic. Because it acknowledges the Holocaust occurred, right? Which, whatever. I sincerely apologize to any convention staff member who ever felt I was anything less than kind or grateful to be included in their event. Unknown to most staffers, contractual arrangements made in advance with cons were occasionally not honored when I arrived, and that made me frustrated. I'm sure it did. That does not excuse me, make me anyone feel badly, and I'm deeply sorry. I'd also like to sincerely apologize to anyone who ever felt my interaction with them, a hug or kiss on the cheek or forehead, was crossing a line. Never in a million years would it be my intent to make anyone feel uncomfortable. Rather, it was meant to show gratitude or support. I come from an affectionately expressive family when such displays are commonplace. And incidentally, I did hear part of Vic's statement that he made at a convention or something, where he was like essentially saying this in quasi tears to a group of people, where he was saying that, he's just very huggy and, very sort of physically engaging in that way, and that, he didn't realize it was not okay or whatever. So, fair enough. Some people are more expressive physically than others, and some people don't want to be physically expressed to. It's a line we're all trying to negotiate, Yeah. Let's see. Hence, I will not be interacting the same with fans in the future. Understand this is a climate we live in and how it's supposed to be, how it has to be. To my fans who ask me for hugs, I'm sorry, but please let me know I'm no less grateful. Well, if they ask you, presumably that's not a problem, but and these, it is a little off point, but like the whole floaty hand thing of Me Too, where you see people in photographs and they're not like hugging their fans anymore, and they've got these hover hand things, is a depressing statement of our times. Finally, any allegation of sexual harassment, sexual assault, or more disturbingly, pedophile are completely and utterly false. My heart weeps for anyone who endures a violation of this kind. So having to be accused of harming others in this way, I have no words. Sincerely, Vic. Fine. Very good. Very good. In his tweet, Vic acknowledges conduct at numerous public conventions, which he downplayed. A hug or kiss on chick may have caused fans to feel uncomfortable. He promised not to interact with them in the future. I do like downplayed, because you're an advocate and you're advocating. So, of course, you're going to color the argument, by saying downplayed. But I take note that you've done that. Okay. Because of allegations circulating on social media about Vic, Funimation asked Human Resources at Sony, which owns Funimation, to investigate. Fair enough. He's not an employee, he's a contractor, but still, they know how to deal with these issues, presumably. So why not? Why not get HR to do it? If they'll do it, why not? Beginning on January the 22nd, 2019, we're moving very fast, the executive director of employee relations, Tammy Denbo, investigated allegations made against Vic by his anime co-star, defendant Monica Rial, by two fans who indicated with Vic at a convention, and by a former Funimation employee. Based on the interviews, Rial and Vic, among others, Denbo concluded the allegations were credible, and the conclusion was reported to Funimation. Okay? On January 29, 2019, Karen Mika, an officer at Funimation, told Vic by telephone the conduct was unacceptable and Funimation was letting him go, effective immediately. They're a private employer. They can do whatever they want. Whether or not they should be doing this is a whole other thing. I think as a general proposition, a lot of Me Too has gone too far. And, whether or not they should be behaving this way, I suppose it's their prerogative. Funimation did not make any public statement about Vic at that time, about the termination of Vic. Vic's public mea culpa cited above did little to quell the public interest in bad behavior, as multiple industry media sources began writing articles. For example, on January 25th, Polygon published an article entitled Dragon Ball Super Broly Voice Actor Responds to Sexual Harassment, where it recounted some of the misconduct went as far back as 2010. In 2019, Anime News Network, which bills itself as the internet's most trusted anime news source, published an article entitled Far From Perfect, Fans Recount Unwanted Affection. In that article, the news network described several stories of inappropriate conduct. Funimation was not the only anime production company to end its relationship. In February, so we're only 10 days later or less than that, we're moving quick, production company Rooster Teeth contacted Anime News Network to issue a statement effective today. Vic Mignogna is no longer part of the cast of whatever, and Rooster Teeth is ending all of its associations. As the comments to these and other articles referenced below show, the allegations against Vic caused social media warfare among anime fans. Yes, the anime warfare has come to my channel too, as I proceed to irritate literally everyone, both the pro-Vic people and the anti-Vic people. The I stand with Vic and the kick Vic people are both supportive and irritated at me at the same time. It's wonderful trying to be neutral. It's a wonderful thing trying to be neutral. Everyone's irritated at me. Appellee defendants Monica Rial, Jamie Mariachi, and Ronald Toy had their own social media confrontations with Vic supporters based about their own experience. The back and forth among anime became so heated himself that Vic himself issued a tweet that called upon the threats to stop. Vic's effort to admonish his fans had little effect, but at least he tried. I don't think I'm big enough to be referenced in an appeal yet. I know I know what's his name? Rikita has been mentioned, but I'm not big enough. Also, like I'm not like pro anyone. So I don't know why they'd be mentioning me. Unless like they're just interested in me like in like my opinion as to like why I think they're right or not. But why cite some random lawyer who says, yeah, I think you're right? I suppose why not too, whatever. Due to continued publicity surrounding Vic, Funimation decided to issue a short statement regarding its decision, which it did on February 11th. Funimation tweeted, everyone will want to give you an update on Vic's situation. Following investigation, we recast Vic in the Morose Monokian Season 2. How did I do? Funimation will not be engaging Mignogna in future productions. In response to continued heated back and forth, Funimation published a second tweet. Part of our core mission is to celebrate diversity of the anime community, which, you know, as a right-leaning person, I want to immediately die when I hear stuff like that. How about celebrating talent or celebrating merit instead of celebrating diversity as such? No, we want to celebrate diversity as a goal unto itself. Okay, that's good. And share our love for this genre and support its positive impact. We do not condone any kind of harassment or threatening behavior directed to anyone. The purpose of this tweet was to encourage civility. Really? I don't see that as particularly trying to encourage civility. I thought Vic was closer. Mono no Kian. Alright, I was reasonably close. Funimation nowhere stated or implied any of its tweets that Vic himself has engaged in harassment or threatening behavior, sexual or otherwise. Well, I don't know about that. The juxtaposition of the two tweets, at least to me, is more suggestive that it does imply, right? It can't like write those two things in a semi-contemporaneous way and not have people read one on the other. So I thought, you know, Vic's argument that you should read one on the other, and therefore it was an implied defamation, was reasonable. Now, of course, we're going to get into public figure status and a whole bunch of other stuff, but like, I don't really agree with that argument. That's not, to me, the right argument. Vic did not deny his behavior at conventions made others feel uncomfortable, which he admitted in a tweet published February 13th. Well, I don't know that he's in a position to deny how other people feel. And people can feel anything. So, like, if you tell me I feel X, it's like, well, unless I know you so well that I know you don't feel that way, you know, I'm not really in a position to affirm it or deny it. You know, if you're my brother and you tell me I feel a particular way, I may know you so well, and be like, no, you don't. You actually feel this. And I might be right. And short of that, whatever. Short of that, you can't really deny how someone else feels. My desire has always been to show appreciation, warmth, and acceptance to my fans and my work. Me being part of this community has given both my work and life such meaning. If anyone has been made uncomfortable, it's not for me to contradict them. Which, you know, Vic did break the one rule of, I think, the social justice outrage mob rules, which is never apologize, because they'll never be satisfied and they'll always want more. So just don't apologize, you know, because you're trying to placate them and they'll never be placated. So I think Vic broke the rules there, and it's impossible for me to discern another person's personal boundaries. As a general proposition, that's probably true. I regret anything I said or did out of ignorance that's put me outside the comfort zone. Yes, the social justice warriors want your blood, Vic. They just want your blood. This is probably not the best strategy. You know, you kind of went on the simp route, and it's not ending well for you. You know. I love my work dearly, as well as the characters I have the privilege to portray, but most satisfyingly of all has been the opportunity to share the love of art form with fans all around the world. I would never have met any of you without it. Meeting each of you has so enriched my life. I'm humbled to receive thousands of encouraging messages. To my colleagues, I consider you good friends. We shared countless wonderful experiences. I never meant to do anything to offend or hurt you. Until these last few weeks, I had no idea animosity existed. I never had anything but respect for you, and I so deeply regret any words or actions. This isn't going to end well. Yeah. In many respects, life is about course correction and growth. So many fans have written me over the years about very personal issues and struggles. I've always done my best to encourage and support them. The truth is, I'm just as susceptible to struggles and difficulties as anyone. I've identified areas where I need to grow, and taking this effort and time to recommit to God and seeking help of a counselor. I'm committed to putting in every effort to improving not only myself, but everyone I interacted with. Each of you deserves nothing less. Please be kind to one another. The very last thing I want for anyone to be hatefully targeted, especially not on my behalf. Most sincerely, Vic. Okay. In the tweet, Vic admitted it was impossible for him to discern another person's boundaries. Which, he probably shouldn't have said, even though it's true. Of course he can't. Again, unless you know the person particularly well, if a person says, these are my boundaries, what basis do you have to deny it? Vic's tweet was picked up by several news organizations. I'm sure it was. Vic filed suit on April the 18th in an effort to hold Funimation liable for its tweets for the separate social media account of its co-defendants. In his petition, Mignogna sued Funimation for defamation, tortious interference, civil conspiracy, and vicarious liability. Funimation, Hope rules. Why did he say so much in his tweets? Because he didn't learn the lesson. He didn't know the lesson that you can't appease the social justice warrior mob. They are unsatiable. So he tried to be a simp and tried to expose his underbelly in the hope that his opponents wouldn't rip his throat out. And unfortunately for social justice warriors, that doesn't work. They'll just rip your throat out. So, trying to placate the social justice warriors, it just never works. I'm so sorry. I didn't know what I didn't know then. They're never satisfied. But he was trying to be a good ally of the social justice warriors, and they ate him alive. Mistake. Not the first person who's made this mistake, incidentally. Lots of people have made this mistake, and lots of people continue to make this mistake. They think the social justice warriors can be appeased. They cannot. Funimation denied liability and pleaded affirmative defense. Funimation contends the tweets were not actionable because they were truthful, not defamatory. They could not show that the published tweets were the actual malice or he'd been damaged. As to Funimation's tweets, it's colorable whether or not it's it's defamation per se or not. Funimation also contends there's no legal basis for the trial court to hold vicariously liable. Under the relevant laws, I understand it because they were contractors. That appears to be true. So, okay, fair enough. And pleaded that Vic was libel proof. Really? Wow. I mean, that's a hell of an argument to argue he's libel proof. So for those of you who may not be familiar with libel proof, it is an idea and it's not accepted by every jurisdiction. And for that matter, I don't know whether or not it's accepted by Texas off the top of my head, although the fact they mentioned it suggests it is. But libel proof is an idea that there are people whose character and reputation is such complete garbage, it is impossible to defame them anymore. And that's just not possible to defame them anymore because their reputation is such in the toilet. I don't know that Vic is quite in that category, but okay. Funimation filed its motion on July the 1st. Monica filed their motions. These motions were released for hearings. Okay. On August 6th, the parties signed a Rule 11 agreement in which they agreed Vic would file his response to the motions on August 30th. I know the Rule 11 agreement is going to be material because I know that agreement is going to at least be in part what is going to guide whether or not the second amended petition is proper or not. So I know that agreement is going to be part of the issue. Vic filed his response early in the morning on August the 31st, along with the motion for leave due to technical difficulties, which is granted. Which, incidentally, I have seen judges and courts burn attorneys occasionally for being late. So, even due to technical failures, right? It's if you wait till the last minute, I once saw a court of appeals burn an attorney for being 15 minutes late past the deadline, and they destroyed the attorney for it. Now, I can only imagine they destroyed the attorney because the attorney had long since exceeded whatever else it was. So it was just an excuse to dunk on the attorney. But Just saying. You do take fate in your own hands a little bit. And if you wait till the last minute, you do take the chance that the technical thing will fall and you won't be able to file and the Court of Appeals will destroy you. So just saying, want to be careful with that. I've definitely seen it happen. Okay. After it's pointed out that the affidavits submitted by Vic from himself, Huber and Slosh were fraudulently notarized, I don't know if it was quite exactly fraud. Beard said he thought, I believe this is correct, and maybe I'm getting this factually incorrect, but I think Beard said that he signed it on their behalf because he thought he could or something like that. So it wasn't exactly quite fraud. It was more like mistake, but either way, it wasn't valid. So, All right. After it's pointed out that they're fraudulently notarized, not a physical presence of the notary, of Vic's lead counsel Tiber when they purportedly execute the affidavits, Vic quickly withdrew the affidavits from Judge Trump's consideration. And incidentally, for whatever it's worth, when I write things, I often float in my writing between saying like the person themselves did it versus the attorney, because like they're doing that here too. This is just like a personal stylistic note where it says Vic withdrew the affidavit. Of course, Vic didn't, right? His attorney did. But when I write these things, I often will say like the person themselves did it, because if your lawyer is doing it, they're speaking for you, so it's basically the same. So I'll do this and say like, this person said that even if their attorney did. So just a little stylistic note. I do that too. In his brief in this court, however, Vic cites the affidavits as evidence without explaining that he withdrew them, and Judge Chepp refused to consider them. Which, incidentally, like, for anyone who like, I don't know if this has ever come up in any of the filings ever, but I'm just going to take a guess that there have been times when like Funimation or Real or someone has said like Vic did X, and I bet you there have been people online who have said Vic didn't do that. That was his attorney or something. And like, to me as a lawyer, it's like a total non-starter, because like, yeah, but it's his attorney, so it's the same thing as saying him. That's like when someone is speaking for you, it is you. So like, yeah, I've just imagined that's come up before where there's been a brief or something where it's like Vic did this, like Vic never did that. That was his attorney. I'm like, to an attorney, it's like one and the same thing. So, that guy, they're lying. Vic never said that. I'm sure that's come up. Just incidentally, I write like that, so yeah. Because he withdrew the affidavits, Vic tried to remedy the lack of evidence by filing a Second Amendment petition 3 days before the TCPA hearing. Yeah, which was like, because was it 3 days really? I thought it was like 7 days before, and there was a rule about 7 days, but was it 3 days? Okay. With new identical declarations signed by the same witnesses and several other attachments, Vic left out of the original response. Defendant appellees objected to the late filing and late submission because after the parties agreed upon deadline and because of surprise, which, as I understand the rule, is a basis to object, right? And it's like, because the rule, I'm going to misquote it, and the Vic people will never be happy with me, because the Vic people get me on the least little thing. When I make a slight mistake, it's just really like nailing me to the wall. I'm going to try anyway. I thought the rule was 7 days. I thought they filed on day 7, and the rule was like, if they didn't say it, that it has to come in automatically. Everyone's like, it says shall. But if it was 3 days before and they did argue prejudice and they struck it down because of that, then like, what have the Vic people been talking to me about? Is this not factually correct? I mean, I assume that like when they're making statements of fact, they're not making that up. So if they say Vic tried to file the Second Amendment petition 3 days before the TCPA hearing, I assume that that's factually correct, right? That's not like a legal argument. That's a factual statement. So I'm like, that seems right. If that's factually true, that's a pretty big deal. All right. They objected to late filings. That's a factual statement, did they? Okay. And late submission because it was after the agreed on because of surprise. Okay. And as I understand it, that would be a valid basis to object according to the rule, right? If it's within the 7-day window, as I understand the rule, if it's within 7-day window and you object, and it is, then you can like not have it in. So if it's within that window, I thought it was outside the window, and that was the argument, but it was within the window. Like, what are we arguing about? What are the Vic people? Why should this come in? Vic people, it's like, why is this? What's happening here? Because this seems like slam dunk for Funimation. So what am I missing? I'm sure someone will tell me. Funimation also argued it was improper under the civil procedure for Vic to attempt to meet his evidentiary burden by attempting evidence to his petition. I have to go into the civil procedure to see whether that's true or not, but it struck me as a little odd if it was. Judge Chip held a hearing on the TCPA motions on December 6th, where he dismissed all claims except for defamation. After ordering the parties to mediate, which was unsuccessful, he ordered dismissing all the claims. In the order, Judge Chop stated he did not consider the affidavits because they're withdrawn in the original petition, and he did not consider the Second Amendment petition because the evidence was filed late in violation of the agreement. Okay, and citing to the record where apparently he said that. So if that's what he said, then the Second Amendment petition isn't the relevant petition. All right, then Vic is screwed. He's screwed. With respect to Vic's claim against Funimation, Judge Chip held all the claims were subject to TCPA. Vic is a public figure, limited purpose, but either way, for the purpose of defamation, and Vic has failed to establish clear and convincing evidence. Yeah, without the Second Amendment being on the record, no problem. After conducting an evidentiary hearing, Judge Chip erred final decision. Yeah, if the second amended was not the operative petition, even the First Amendment was nowhere close to right. The Second Amendment was more than enough in my view, but the First Amendment was it was essentially a bare bones notice pleading, which is enough to get started, but is not enough to get you where you need to be on this standard, right? You had to amend it, and he didn't amend it. And if he tried to amend it by being within the window or outside the window, depending on your frame of view, if the window is 7 days and he filed it 3 days, so he's outside the window, and they objected, and he said, I'm not going to bring it in because it's a violation of agreement and it's unfair surprise, so you can't bring it in, then Vic loses. End of the game. It's like end of the game. And there's nothing worth arguing about anymore. It's just the end of the game. There's no reason to reverse. When given an opportunity to provide, they failed to do so. Specifically, failed to show that true tweets were defamation by implication. Well, in the original, they surely did. If he made the showing, they failed to show with actual malice. They knew it was false. It showed actual damages because they're not defamatory per se, which, I don't know. I think they kind of were, but, again, they're writing from their point of view. They're advocating. So, it's a plausible position to say that's not defamation per se. I think ultimately that's wrong. I think the better view is it is defamation per se, but I don't think it's outrageous to argue the contra. If I were the lawyer, I'd argue the contra because I can make the case for my client. My job as a lawyer is to advocate for my client. As long as I can argue it with a straight face, my job, and I think it's the tactically strategic right thing to do, I should be doing it. So, would I make this argument? Of course I would. Of course I'd make this argument all day long. I think it's ultimately the wrong argument, but it's plausible, so why not make the argument, Because you never know what the other side's going to do. You never know if the other side's going to drop the ball or whatever, right? So it's like, in the abstract, in the purity of the thing, it's like, the analysis would tend to suggest the otherwise, but I don't know if the opponent's going to drop the ball, which apparently they did. So of course I'm going to make the argument because if they drop the ball, I win. Because I didn't make a blatantly frivolous argument, So it works for me. They failed to show tortious interference. They sure did on the originals, I'll tell you that. Failed to show any basis for holding Funimation vicariously liability. Funimation did not control on their personal social media accounts, neither of them were acting with the course and scope of their employment or agency relationship. Again, they're arguing from their point of view. Do I think this is a plausible argument? Yes. Do I think it's ultimately the right argument? No, I don't think it's ultimately the right argument. I think the other argument is better. But again, if your opponent drops the ball, you win. So why not make the argument? Because your opponent dropped the ball, so you win. Did not abuse discretion, refusing to consider the attachment or their for the reason they should be affirmed below. Okay. We might skip directly to the abuse of discretion issue, because for me that's like the abuse of discretion on a second amended petition is the ball game. For me, that's the ball game. Everything else is kind of incidental, right? This is like trying to figure out what issues really do matter and what don't matter, and it's an issue of professional opinion, right? I'm giving you a professional opinion as to what issues I think do and do not really matter. A lot of these issues are like, I understand the point of it, but as to like the ultimate issue, does it really matter? Not as much as some issues. Some issues are more important than other issues. I think we can all agree on this, right? So it's like, for me, I'm like, okay, what is the most important issue? What is the question? What is the question? We're spending a lot of time trying to figure out what is the question we're supposed to be asking. So for me, the question is, what is the operative petition? If the second amended petition is the operative petition, the judge screwed up. If it's not, the judge is right. If the second amendment petition is operative, Vic should win. If not, Funimation should win. So for me, that's the operative question. Like, everything else is like tilting at windmills or whatever the right expression should be in this sentence. So much surplus. All right. We're going to talk about why the TCPA is good. We don't need to talk about why the TCPA is good. It's law. Let's just go with that. We're required to produce good and specific evidence. Because Vic alleged defamation by implication, further show objectively reasonable person would ascribe the meaning, according to a case and precedent. Fair enough. Trial court properly dismissed claims because they failed to meet him. The 2 tweets at issues contain truthful, non-defamatory information. Its aftermath. Okay, so here are the tweets. Everyone, want to give you an update on the Vic Mignogna station. Following investigation, we have recast Vic and will not be engaging Vic in the future. Fine. Part of our core mission is to celebrate diversity and share love. We do not condone any kind of harassment or threatening behavior directed at anyone. All right, to me, I read one and lie the other because of the time, right? The contemporaneousness of the nature. It's like, of course you'd read one and lie the other because they're very contemporaneous, right? In his brief, Vic argues, when read together, imply that they determined Vic had engaged in threatening, harassing behavior. Okay, I think that's probably a correct argument. Let's see what Funimation says. Let's see if Funimation can convince me that is the wrong argument. Because, like, to me, that's like, yeah, that sounds like the right argument. All right, Funimation, why do you say it's the wrong argument? Let's see if you can convince me. Vic's proposed interpretation says more about Vic's guilty conscience than it does about the tweet's objective meaning, particularly concerning the surrounding circumstances. This is not a case such as other cases where words such as crime, felony, and welfare claim strongly imply commission of a crime or other wrongdoing. Here, by contrast, Funimation nowhere stated or implied in either of the tweets that Vic himself engaged in threatening or harassing behavior. I don't agree. The first tweet offered truthful, non-defamatory information about his decision to sever. I agree with that. The first tweet is fine. It was factual, to the point. No problem. We're great. Yep, we're good. In publishing its second tweet, Funimation confirmed its uncontroversial position that does not condone harassment or threatening behavior, which echoed language from Vic's tweet in which implored supporters to stop making threatening behavior to others. In the abstract, yes, but unfortunately the timing of the thing suggests you should read one and lie the other. If they were like very distant in time, then you wouldn't read one and lie the other, but they're so close in time, it would be reasonable to read one and lie the other. So I don't agree with this. Funimation's second tweet does not reference Vic, nor does it reference the FNMA in investigation. Accordingly, no reasonable, ordinary intelligence, nor objectively reasonable reader would interpret the tweets. Well, I don't know, man. I'd like to think I'm a reader of ordinary intelligence and objectively reasonable, and I do not agree. I do not agree. The timing of such is that I think you would read one and lie the other. I do not agree. Nope. But, it's an argument from their counsel. So, of course, they're going to argue it. Again, this is a plausible position. I think it's a little bit more on the, I think it's kind of tilting a little bit more towards the implausible, but it's plausible enough. So, of course, I'm going to make the argument. Because, again, if my opponent drops the ball, I win. So, I'd make this argument. I think it's the wrong argument, but I'd make it. even if the court were to make, because again, I'm advocating for my client, and I don't know what the other side's going to do, and what issues they're going to pick up on and what they're not, and what balls they're going to drop and not. So, like, I'm going to argue everything I think that's plausible and see what happens, it's a plausible position. I just don't think it's the right position in the end. But if the opponent drops the ball, what does it matter? If we're to accept the tweet, it was required to show they published it with actual malice. Actual malice means malice to the truth, not malice to the person. That's the way I like to phrase it, because I think it's just simpler. It's malice to the truth, not to the person. Okay, they spend only one statement to it by saying Funimation knew it was false and cites no evidence. In the pleadings, it was, this was a bit of a criticism of mine. Okay, more than a bit. I felt that in the original and First Amendment petition, for that matter, he didn't do nearly enough in dealing with the public figure status. Like, I know it's coming, so I would have just tried to write something about it, try to head it off at the pass. But Tybeer didn't choose to do that for some reason, and so there's nothing there dealing with it. It's okay. Yeah, the statement of malice is not enough to show malice. Yeah, unless you have some proof about that. Fail to prove about knowledge or recklessness. While it's unclear from his brief, I thought the brief left something to be desired, Vic may argue in reply that the post-tweet failure to clarify findings somewhat shows Vic that Funimation must have intended to imply its investigation found it. But Funimation's after-the-fact silence is not evidence of actual malice. Silence is not usually proof of anything as a general proposition. Thank you, Mega Monster. I try to argue in good faith. I just try to argue, call it how I see it. The only evidence of the trial record of Funimation's state of mind was Funimation itself, which conclusively negated any evidence, particularly by implication. Scott Barrietto testified the purpose of the additional tweet was respond to continued heated back and forth of his efforts to do civility. Well, he did a very poor job at it. Funimation nowhere stated or implied that they engaged in harassment or intimidation. Well, you may think that. That may not have been your intent, but as an objectively reasonable person reading it, I do not agree. The extent to which Vic argues in the reply that reached the wrong conclusion about conduct because Vic denied the allegation, the argument does not support actual malice. Well, that's true. Just because the other person denied it doesn't mean that's malice to say the other, right? If mere denial was enough, then we'd all be sunk. So you're guilty of this. No, I'm not. Oh, now I can't report on it. Of course not. That's not the relevant standard. Vic failed to show actual damages. Fair enough, because, all right. So Vic wants to say it's a per se. Let's find out. Vic argues not required to prove evidence because they accuse him of crime of sexual misconduct, which would make him defamation per se. The argument should be rejected, even assuming a reader of ordinary intelligence, ordinarily reasonable observer will interpret it. I'm accusing him of harassing or threatening behavior. Those bare accusations not contain statements engaged in a crime of sexual misconduct to qualify as defamation per se. All right, well, I need to go back to the tweets and actually read them again to answer that question. So let me go back and see what it actually says to see if I agree with that. How carefully did they word this? Let's see again. Part of our core mission is to celebrate the diversity of anime community and share our love for genre and its positive impact. We do not condone any kind of harassment or threatening behavior directed at anyone. Man, that's tough. That's tough, because now I'm doing a couple levels of implication, right? Because the first level of implication is to read these two statements in the same universe, right? So I can say, and Vic argues, and I think he makes a good point. In fact, I said he thinks it's the right point ultimately in the end. You say Vic Mignogna in the first one. You say we do not condone any kind of harassment. Therefore, you're saying Vic did harassment. I think that's a reasonable implication. Now we're on to step 2 of the implication, where the argument becomes a lot more complicated. Defamation per se applies to certain kinds of things. It applies to like one's trade, it applies to sexual misconduct and so forth and so on. So you would have to read this tweet as being a defamation per se argument. It's not on its face. It's not saying we don't condone sexual harassment or sexually threatening behavior, right? There's nothing about it on its face that says it. But you would say to yourself, aha, what I'm going to do is what they really meant was sexual, because the whole context of this, this whole context of the milieu in which this tweet is being held, right? The whole context is that sexual harassment, sexual misconduct, right? So that's the whole like zeitgeist of this thing that this universe is happening in, right? So I want to interpret this statement, which on its face doesn't relate to a sexual matter, but I want to interpret it in light of the overall context and the background of saying what they're really saying is sexual conduct. That's a tougher argument. That's a much tougher argument. I think it's easy to read these two tweets in light of each other. It is a harder argument. I wouldn't say it's impossible, but I'd say it's definitely harder to argue in the light of the background of things that Funimation isn't saying. Funimation isn't saying sexual. The context overall is sexual, right? Because sexual harassment and stuff like that, and the milieu and all that stuff is sexual. But to imply the sexual where Funimation themselves didn't say it, I think Funimation has the better end of the argument, to be fair. So that's how they get out of the defamation per se, and go to defamation per quad. I think Funimation has the better end of the argument. I think they lose in the argument that you can't read this in light of the other one. That doesn't make any sense to me. But to say it's unfair to read it in light of general accusations when we didn't say that, it's a tighter issue. It's tight, but I think Funimation wins in the end. It's a tighter issue though, but I think Funimation wins that one. Yeah. Vic's argument should be rejected, even assuming a reader of ordinary intelligence would interpret the statements. These bare accusations do not contain they engaged in crime or sexual misconduct. It's a legally precise argument. It's a legally technical argument. But I think it's the right argument. I think it's the right one. Accusing someone of crime or having a foul, loathsome disease or engaging in serious sexual misconduct or defamation are examples of defamation per se. Vic does not identify a crime implied by the tweets. Yeah. Because you have to read them not in light of what Funimation said, but you have to read them in light of the overall atmosphere. And you have to read them on what they really meant was, no, I don't think you can get where you need to be. I think Funimation, maybe Funimation was very, 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 very careful in the way they phrased their tweet in the first place to avoid this issue. Maybe they wrote it very deliberately for specifically this reason. But if they did read it that way, but for specifically this reason, then, well, their lawyers gave them good advice. And they wrote exactly as much as they could and nothing more. Funimation has the right argument. Yep. Because the tweets were not defamation per se, Vic was required to produce actual evidence. Vic failed to produce so because the evidence was excluded. Yeah, that's right. All the things that would be like the per quad in order like the damages, right? You're thinking to yourself, oh, there's plenty of damages, right? Right? I could show all the things he's been excluded from. I could show all the job opportunities he's been excluded from. I can show all these statements. But of course, none of that stuff exists. None of that stuff exists because it was all thrown out. Right? Oh, that's no problem. I got plenty of evidence. What evidence? Uh-oh. Here's all the ways I've been hurt. What ways have you been hurt? Oh, Jesus, right. None of it's here. Uh-oh. My God. Oh, man. Even if Judge Chips considered these materials, the speculation he had valid contracts with dozens of conventions enlisted in my amended petition does not contain evidence of damages resulting from the tweets. So he's arguing there's a lack of causation. I don't know. I'd have to read it a lot more precisely to like make the determination, but on the surface, I'd say it's a question for the jury. Because the causal element, like, did the tweets cause these damages, is the causal element, right? So the Funimation is arguing the causation is missing. Like, he's saying, well, here's a whole bunch of contracts I've had canceled or been modified or whatever, and here's a tweet. Funimation's saying, well, you missed the step in the middle where you say one is responsible for the other. That's causation. It seems like more of a factual question to me for a jury to solve, right? I mean, there's probably enough on my surface level reading for this to be a jury question, so I think that Funimation's wrong about that. But, fair enough. Above all, fatal to the claims is failure to show causation. Yeah, all the conventions canceled before Funimation published its tweets. I love it. I love it. All the things that occurred before the tweets, therefore they can't be caused by the tweets. Whatever else it wasn't the tweets. I love it. And if the timeline's right, it's a unbeatable argument. We don't do reverse causality in this universe. Can't go backwards in time. So it wasn't caused by the tweets, whatever else we did. You can't argue with that. If the timeline's right, the timeline's right. Funimation tweets could not have caused the problem. Okay, well, if that's the timeline, that's the timeline. We might have done a whole bunch of other stuff that caused the problem, but it wasn't our tweets. You can't argue with that if that's the timeline. No reason to reverse for tortious interference. When they forwarded the Cape Copper case to make Funimation, Vic failed to provide any proof they interfered with any existing or prospective contracts, much less any competent evidence caused actual damages. Well, it certainly wasn't done very well in the hearing, and the Second Amendment may not be the operative one. Fatal to the appeal is that he failed to link to any Funimation statement to any specific loss of business. Even showed potential customer desired not to book a venue after reading one of the statements. Plaintiff would still have to show which statement the prospective customer read, which presumably you could do by, as I sort of alluded to earlier, you could do it by deposition, declarations. Hell, I'll take a random email from someone, which again, the Vic people who have been endlessly critical of me for not being aware of every little fact of this, have been saying, well, all that stuff was there. It was just thrown up by the judge. But, if it was thrown up for a reason, it doesn't exist. So, £5 from Authorium. Thank you for this support. As always, it is greatly appreciated. Thank you. The question is, if the stated purpose of TCPA is to dismiss meritless lawsuits, would that affect whether the appeals court could consider the excluded filings? No. The TCPA should not. Well, let me modify that slightly. The TCPA could, in and of itself, as part of the statute, modify the procedural rules. So to the extent the TCPA modifies the procedural rules, then yes. But that's not my understanding as to this particular aspect. My understanding as to this particular aspect is that this is not an aspect that would be governed by the TCPA as such. This is governed by other rules, including when things can be offered and not. And maybe it was the TCPA that provides that 7-day window. Or maybe it was a different rule of appellate procedure that provided that window. But either way, it's there's a rule out there about certain things, and so I don't think the way you're asking me the question, the way I'm interpreting the question, I think the answer is no. The fact is the TCPA as such doesn't impact it. It would only impact it to the degree that the TCPA modifies the procedural rules. And if it doesn't modify the procedural rules, then we just go to the standard procedural rules and when you can offer certain things and so forth and so on. So it's not because TCPA, therefore something else. The TCPA would have to modify the rules as part of the statute, which you wouldn't expect it to do. I suppose it's possible. The First Amendment petition does not identify a single convention terminate after the Funimation tweets. Instead, it was before the tweets. Okay, yeah. Meaning the evidentiary person, the groups, all the appellees together, full expected to participate because of appellees' tweets. These conventions did not identify them. This sort of speculation is insufficient under the court's opinion. There's no reason for the court to reverse. Sounds right. To establish basis, you'd have to show that they were employees and they were acting in the course. They failed to make either showing. Judge Chapp correctly ruled that they show they're independent contractors, non-employees or agents. Okay, yeah, apparently this is Texas-specific law, right? Because it cites Texas 2018, right? So apparently in Texas, being independent contractors is not enough for vicarious liability. Okay, I mean, that's the Texas law. That's the Texas law. Fair enough. I mean, Texas can do what it likes. So if you're an independent contractor, your employer is not responsible for what you tweet. Okay. Employees are insulated from liability for tortious acts of independent contractors. Okay. If that's Texas law, that's Texas law. Which, to the best of my knowledge, it is. To the best of my knowledge, they are independent contractors. So, fair enough. Okay, I've got an emergency alert. Hold on. Flash flood warning. So, in addition to every other problem happening in the world right now, I got a flash flood warning. So, good times. All right. Provide no evidence to their employees. It is brief. Retains control. They should be rejected. The course and scope element arises only fall within employment. Act must be of the same nature. They directed the work does not equal supervisor liability for what they posed. Fair enough, right? We directed them how to do voice acting, not what they should tweet. Okay. Rial testified she used Twitter for her voice, her job as voice actor, does not support any inference Funimation controlled what she posted about tweet. It's the fact that she was using them professionally for professional purposes doesn't implicate Funimation. That Funimation directed it, authorized it, or that she'll be responsible because she's an independent contractor. So, the fact that she's using it for professional purposes, it's like, I don't know how that's our problem. Okay. The Rial asked Funimation for how advice to deal with the pressure does not show that Funimation has the right to control. Determine whether the employee has the right to control the progress. The fact that you asked us for advice isn't enough. Okay. Funimation silence somehow communicates affirmation of apparent authority. It's been said silence speaks volumes, but truth is silence as no one truly knows what it means. It invites speculation, and our Supreme Court has said it's evidence. As a general proposition, silence is not evidence of pretty much anything. This is not like a case in which Vic cites where other conduct from the principal in the case is clothed against an indicia of authority, and the principal's silence was manifestation. The Pan American Court described the case as a principal where the one had formal business relationship, knew his agent would be contacting third parties, including email, and offered cubicle, landline, and all that kind of stuff. Held the principal clothed the agent with the indicia of authority. This case is distinguished. Vic provides no evidence that Rial had actual authority, and she had no such authority. It wasn't an agent or employee. Funimation had no control, nor take steps to indicate that Funimation took steps to clothe Rial with authority to speak. Sounds like the right argument to me. Sounds like the right argument. This is one of the things the Vic people have been criticizing me over. Is well, she was using it professionally, using it for all kinds of things. And well, did Funimation control? Did they provide an indicia? Did they they doing those things? No. Okay, well, that's interesting, Vic fans, but doesn't seem like it's enough based on what I'm reading. So, okay. Vic cites other cases. They don't support the authority. Rial is not acting with the scope of employment. It reads more like a closing argument than a clear explanation. Yeah, fair enough. TCPA does not apply to conspiracy claim, provided the conspiracy claim fails as a matter of law if the underlying claim fails. Fair enough. You can't have a conspiracy unless you have an underlying problem, an underlying thing. You can't have a blanket conspiracy. That's true. Vic should reject Vic's argument TCPA does not apply to conspiracy. The case relied upon Vic is easily distinguishable. Kawak involved a claim for fiduciary duty. When he sued, the former employee filed a TCPA motion, which argued communications for the kickback recovered by TCPA right of association. Fort Worth Court of Appeals rejected the argument, holding a conscious interest test requires more than two tortfeasors conspiring to act tortiously. The case permitted here is not about tortfeasors acting for their own selfish benefit. Well, arguably it is, but, rather this case involves an anime studio's public online comments about public figure whose misconduct had began to become a matter of public concern. I don't think it's as easily distinguishable as Funimation wants it to be. Nice try, but it's and I don't even think it's that big a reach. I just don't think it's as distinguishable as they say. I think it's kind of closer. Exact type case was meant to address. Okay. Unlike Kawak, Funimation did not rely on the right of association as its basis. Argued primarily statements were about Vic as exercising of free speech, defined as communication related to health, with issues relating to health or safety, well-being, or public figure. As such, the narrow analysis of right of association does not apply. Funimation is exercising its right of free speech. I don't know. Could go either way, but I don't think it's distinct as what Funimation is arguing. I think it's a little bit closer than they are letting on. But that's what I think. Funimation presented evidence that's exercising its right, which addressed communication in general clearly as qualified as individuals who join together. Fine. Vic failed to support elements of conspiracy with clear and specific, which further justified dismissal. Like, for example, providing the Discord or any evidence of it would have been real nice. Instead of pointing to direct or circumstantial evidence, the appellees reached a meeting of the minds in a course of action, which is, kind of what you need for a conspiracy. Took one or more overt acts, which is also what you need for a conspiracy. Agreement, overt act, yeah. Vic asked his court to make multiple reasonable inferences based on one-sided reading of the facts. This is similar to Vic's argument where the judge criticized Vic's counsel for heavy reliance on rational inferences. Fair enough. You can use rational inferences. They're not barred. They're not verboten, but by the same token, you can weigh them accordingly. Fair enough. All right, now we get to what I consider to be the big issue. We finally get to what I consider to be the big issue. We've been teeing this up for a little bit now. Been teeing this up for a little bit now, as we have gone over some of these ancillary issues, which are kind of like, whatever, and been giving opinion on some of this stuff. Where it's like, whatever. But now we get to the heart of it. We get to the big boy issue. Is the Second Amendment the operative petition? That is the issue that is going to make or break this. If the Second Amendment is not the operative petition, Vic loses. If it is the operative petition, Vic should probably win. But if it's not, Vic is done. So this argument is what we call in law dispositive, because it would dispose of the issue. This is a dispositive argument, in my opinion. If Funimation wins this, that's the end of the game, as far as I'm concerned. Let's find out if they're right. Vic argues that Judge Chup should have considered the Second Amendment and its attachments in deciding whether Vic had met its burden to withstand. Vic's argument should be rejected. This parties agreed pursuant to Rule 11 that Vic would file his response to the TCPA motions by August the 30th. Vic violated the rule agreement when he filed a Second Amendment petition with newly signed declarations to substitute for the fraudulent ones 4 days after the agreed upon deadline. So this is going to get into whether or not the Rule 11 is operative here? Because I know that was like Chup's argument, right? Is that the Rule 11 was not operative. As I understand it, I don't want to necessarily put words in Chup's mouth, but as I understand it, not Chup, apologize, the Beard's argument. As I understand it, Beard's argument was that the Rule 11 agreement was written in a very sort of clever way, so that it did not include this. So he was trying to write the Rule 11 thing in such a way that he could get this in through a backdoor thing. So one of the issues is, did the Rule 11 apply to this or not? And hopefully Funimation is going to cover that, because I'd like to hear what they have to say about why the Rule 11 did or did not apply to this. Because again, I've tried to say this before to the Vic people. It's one of the things is, because they all go to this rule that says shall. And I'm like, yeah, well, rules can be modified by a whole bunch of things, not the least of which is agreement between the parties. If you have an agreement between you, that's probably going to beat it. So let's find out. At the hearing, Judge Chup stated on the record he did not consider it. I really wish we had the direct quote rather than just a citation. In order to memorialize his rulings, Judge Chup questioned the propriety of Vic's late Second Amendment petition, stated that he, we're going to have a quote now, stated he did not consider evidence submitted after the agreed upon deadline in the Rule 11 agreement, with exception of plaintiff's response to defendant's TCPA submission of this without the withdrawal affidavits, which is deemed timely by the order. Judge Chupp refused to consider the Second Amendment petition as attachments. As a bit of a conclusion, I don't think it's like completely beyond the pale. Judge Chupp said he did not consider evidence submitted after the agreed upon deadline in the Rule 11 agreement, with the exception to the response to the defendant's motion to dismiss, which is deemed timely. Therefore, he refused to consider it. Well, yeah, that's going to get into whether or not the Rule 11 agreement binds this or not. So, and Beard's argument is, at least in part as I understand, that this shouldn't be governed by Rule 11. So let's read on. Judge Chupp did not abuse his discretion by enforcing the Rule 11 agreement against Vic, holding that when a movement agreed to delay hearing as long as non-movement filed his response, but non-movement filed a response just one day, trial appellate courts erred in considering that affidavit. Okay. Holding that when Rule 11 prerequisites are met, trial courts have a ministerial duty to grant relief in strict accordance. Ministerial just means like rubber stamp, basically. It's basically like just, if you agree it, just do it. There's not, ministerial just means, I don't know a good way to phrase it other than it's rubber stamping, basically. Moreover, the TCPA's discretion of the trial court should consider the pleadings in supporting and opposing affidavits does not provide litigant carte blanche to submit evidence by filing it to the late petition. Texas Rule of Civil Procedure precludes a party from attaching purely evidentiary matters to a pleading. Rule 59 prohibits Vic from attaching declarations, tweets, emails, and timelines to his petition to circumvent his failure to file a response with properly notified affidavits when included attachments. Precludes a party from attaching evidentiary matters to a pleading. I'd have to really get into what the rule actually says. It can't include any evidence as attachments, really? Prohibits Vic from attaching declarations, tweets, emails, and timelines to his petition to circumvent his failure to file a response with properly notified affidavits with all the included attachments. While Judge Chupp did not cite Rule 59 as a basis for refusal to consider the attachment, the rule was raised at the TCPA hearing as a basis and provides additional reason why the trial court ruling was correct. In his brief, Vic tries to shift the burden to Funimation other appellees to show they were not surprised or prejudiced. But the prejudice to Funimation's evidence. Vic failed to file a timely, complete response to the motion supported by properly notarized affidavits, even after all the appellees agreed to continue the TCPA hearing to allow him additional time to respond. Further, as discussed, Vic's Second Amendment petition contained new allegations that Vic had not included in his prior pleading, along with new evidence that he failed to include in his response. Allowing Vic to escape his agreement prejudices Funimation. They're not getting into the exact wording of the agreement, which is a little bit annoying to me. And I don't know if they're going to get into it later. But I'd like some analysis as to the exact agreement and why they think it does or does not apply in the circumstance. They're offering it conclusorily. They're saying, well, it doesn't govern. But why? What is the exact language of the agreement? Why does it or does not apply to the situation? If you feel you've got that solid an argument as a matter of contract, basically, because that's what the Rule 11 agreement is. It's just a contract, right? It's an agreement between two parties with consideration. It's a contract. So, if you think you've got that good of a contract argument, then, what's the exact language of the contract? I don't know if you're going to come back to it, but the fact it's missing right now is kind of irritating me. Vic rehashes objections he made in the affidavits submitted in support. Because the trial court denied the objection, Vic argues the trial court's findings that Vic is a public figure, and therefore the TCPA applied to Vic's claims against Funimation were based on inadmissible evidence that therefore constitute reversible error. As an initial matter, regardless of the trial court's ruling on Vic's objections, there is more enough evidence in trial court record to establish Vic as a public figure. Vic is a public figure under the current case law. Under the current case law, I don't even really think it's a close issue. He is So they're not going to talk about the Rule 11 agreement. Just going to blow by that completely. Well, that's disappointing. That's disappointing. They're blowing by the issue. If you really feel your agreement is that solid, then argue the specific language of the agreement, why it doesn't apply to the situation. You're not mentioning the exact language of the agreement. It's like, so unfortunately, it does not appear that Blackleaf will be able to stamp a win for Funimation today, as much as I was hoping that they were going to really raise the issue and make it dispositive, where I could say, okay, Funimation is just going to win this. But unfortunately, maybe because it's not there, Funimation did not do that. Unfortunately for them and for us, we will have to continue in a realm of relative speculation about what will happen rather than here's what is going to happen. So we will have to take our guesses at it because it's a little thin in the argument where I'm like, this is the issue, and it left me unsatisfied. Disappointing. Yeah, we're going to argue over whether Vic is a public figure. He's a public figure. He's limited purpose, but he's a public figure. Properly overruled Vic's objection to the affidavit. Made correct evidentiary rulings. Contrary, adequately explain the basis for personal knowledge. Under the law, corporate employees are generally presumed to possess knowledge of facts they learn in course of employment. The other vice president of operations. Oh, we're going to get into the hearsay thing. Am I going to have to do the This Is Not Hearsay song again? For those of you who missed it the first time, we could do the This Is Not Hearsay song again. We can do that again. The vice president of operations says she's familiar with Funimation business practices. Mika also recounted specific communications on the call and informed Mignogna his conduct was unacceptable, and the Funimation was terminating his contract. Thus, the facts stated in her affidavit were sufficient so she was competent to testify. In addition, Judge Chepp properly overruled Vic's hearsay and best evidence objections. Mika's testimony about the allegations on social media of inappropriate conduct was not being offered for the allegations of truth. This is not hearsay. It's not being offered. Okay, never mind. We're gonna, yeah. Not being offered to show reasons. Vic freely admitted the facts stated in the affidavit during disposition and his petition, so a trial court ruling could not have resulted in irreversible error. Last, Vic argues that Judge Chepp should sustain his objection, which provides as follows. Funimation is not responsible for any tweets or other social media on commentary by the co-defendants. Funimation does not have any control. Real and market are not evident. Employees are agents, and they don't have actual apparent authority. The other voice actors work for them are independent contractors. They're not only voice actors as employee or agents. For its parts, Toei is the fancy. Toei is not employee. This is not even like hearsay. These are not statements of anything. These are just like, we're not responsible. It's very conclusory. Vic argues the statements about business relationship were legal conclusions. No. Properly overruled the objection. Vic cites to a bevy of cases that do not support the evidence they should have been excluded. Needless to say, actual apparent authority to conduct a warrant is different from actual apparent authority. Yeah. Funimation has no duty to control. And now, is it conclusory? I don't know. Is it a legal conclusion? Whatever. It's a statement of our view of the facts. It's like, we're not in our view of it. That's fine. I don't care. It's not the issue in any way. It's not, the case is not going to rise or fall because of the inclusion or exclusion of this paragraph. We could exclude the entire paragraph and it wouldn't get you anywhere. It's just like, here's what we think about our own responsibility. Exclude the whole paragraph. Does it matter? Not really. Not really. It doesn't get you anywhere. Why argue about it? They overruled objections from the Sony Protections and Employee Relations. They're not competent to offer the following testimony. When my investigation began, there were allegations on social media that Mignogna had engaged in inappropriate conduct with female friends at anime conventions. Vic contended Delbo lacked personal knowledge to allow statements. Why? Dembo's testimony is not being offered to show the allegations reported on were true, instead offered to show her impetus. This is not hearsay. It's not being offered for. Okay. It says hearsay rule does not apply. Explain her affidavit, she performed scores of investigations. I don't need it. I'm sure she knew about the tweets. It's fine. They overruled the hearsay objections to Scott Barrieto's affidavit. The out-court statements recounted were not inadmissible hearsay because statements were not being offered for the truth of the matter. Show Vic as a public figure. Vic also complains that Barrietto did not have personal knowledge sufficient to authenticate publications, which include several publications about Vic and allegations. Judge Chip properly overruled. First, testimony from a witness with knowledge, such as provided, is not more sufficient to meet the threshold for authentication. Barrietto testified that he monitors media and social media posts related to, which is qualified to authenticate articles. Sounds like it. Because testimony from witness with knowledge authenticates them, they're overruled. Okay, yeah, this is my job. I see this stuff. I saw this stuff. Authentic enough for our purposes for today? Yes. Online media articles which provide no extrinsic evidence required to be printed in it. Properly overruled Vic's hearsay objections. We're not hearsay because they're party admissions. That too. Not admissible hearsay because they're not being offered truth to show that they're a public figure. He's a public figure, guys. Out of court statements if they're offered for purpose other than truth. Yes, they are. That's like pretty core. Funimation award attorney's fees and expenses, and we're going to argue over the money. There's no reason for this court to disturb the trial court, certificate of compliance, blah, 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 whatever. Okay, great. So we're done. So that wasn't so bad. We got through 71 pages in an hour 16. That wasn't so bad at all. So, I thought on the whole that Funimation's argument was pretty good, and I'm very sad. I'm very sad because maybe Funimation has a different view of it than I do as an outside observer, which, But for me, the core issue, and maybe it's done by because it could be that the defendants split the issues up among their briefs because, it wouldn't be unusual for defendants to coordinate with each other, right? They're all legally distinct, but they do talk to each other. So it could be the case that one of the other briefs from one of the other people is going to more focus on that particular issue. Because they don't necessarily all have to say the same thing 3 times. And maybe they divide it up amongst themselves or whatever. But I was disappointed because I'm like, this is the issue. And then we got there and I was like, oh, well, it's you're not going to say what the actual language of the agreement is or why it folds into this or whatever. It's just very conclusory. Now, maybe they didn't say it because the language isn't as helpful for them as they wish it was. So maybe Ty has the better end of that particular argument. Maybe he has a better end of, when you look at the exact language and you look at what exactly says, this doesn't cover it, and therefore I was covered. Now, I didn't think that was particularly well raised on Ty's initial response. Maybe it'll be better covered on his reply brief. One can only hope, because I think that's the positive issue. But I was disappointed because I was all ready for them to provide the coup de grace. I was all ready for them to give me the rule and give me the agreement and show me exactly why and be like, this is devastating. End of case. We can just close it down. But sadly, no. Sadly, no, I can't do that, and we have to continue with more briefs, which I guess is good or bad, depending on your point of view. But I think that is this positive issue. And, so we'll have to see. And we'll also have to see how Ty responds to it in his reply brief on that issue. But we will get to some of the other ones from Funimation, or the other defendants, on a different stream. We'll do the other ones too. We'll do Monica, and we'll do Toy, and we'll do them all, and see if they have anything that they want to offer. Overall, I thought that Funimation's brief was very good. They argued for their side very well. There were a couple issues where they were I thought legally in the wrong, but on the balance, I thought that they had it basically right. I think Vic is a public figure. I think they made a very good argument why the tweet in question is not, and they're really just a vicarious liability issue, right? So Funimation's only real exposure is from the tweets. Unless again you can show conspiracy, which they didn't do very well. But Funimation's only exposure is vicarious, so or from their tweets, and neither one gets them where they want to be. The tweets in the end are not defamation per se, because you have to imply the overall context, and I don't think you can get there. So I don't know if they worded it very carefully, deliberately, but I think Funimation looks like they're off the hook. I think they're correct that these people are not their employees. I think they're correct they didn't have control of it. I think they're correct that that there's not damages and they have to show. I think they're correct that this public figure. So I think Funimation's probably off the hook. Maybe because they were very, very clever. But if they're very, very clever, then they just have good attorneys and they know what they're doing, and so be it. So, as the Funimation, I think they're probably off the hook given what we know. I think even if the Second Amendment is operative, um, unless the Second Amendment really has stuff about the conspiracy, which I haven't read it because it's so long. The Second Amendment petition, I forget how long it is, but it's really, really long with a lot of stuff attached. But unless they had evidence in the Discord and show the agreement, show the stuff, then I think Funimation's off the hook. But we'll have to get into the other people's responsibility later, because it was some of them who were calling the conventions and really getting them, really trying to get cancel Vic and all the rest of it. So I think Funimation's argument for their dismissal looks pretty good in the end. So I forecast Funimation to win. As to the other people, I guess we'll do their briefs another day, and we'll see what we think and see if they can persuade me as to some of this other stuff or whatever. Funimation, I think they're probably going to win. I'd estimate 85% Funimation to win. I just don't think Vic has really many good arguments left, and I think even with the thing, I think that they're probably off the hook. So yeah, I think as to Funimation, probably 85% for Funimation to win. We'll have to look at some of the other defendants on another stream, but good stuff. But if you enjoyed this stream, I'd appreciate it if you give me a thumbs up. I appreciate it as always, and we'll see what's going on, and I hope you enjoy this. So, excuse me, but we'll get to our stuff probably later, and we'll get to it maybe tomorrow. And until later, my friends. Also, incidentally, before I leave, one little item of personal note. I'm trying to put together a compilation best of video. So I'm looking for 5-second segments from previous videos that you think best that demonstrate my personality or best show what this channel is trying to be, the uncivil side of law. So if you have a particular favorite 5-second moment or 5-second thing, if you can provide a timestamp to the relevant video as a comment or something, I'd really appreciate it, because I'm trying to put together compilation video as a new channel trailer. So don't just say, oh, that the time you discussed whatever. I need the timestamp so I can actually go look and see if I want to include it. But that's a personal note. Anyways, until later, my friends. Hope you're well. Cheers and goodbye.